Court does call the case of People versus Yahan.
Good morning, Chico, on behalf of Mr. Morita. Would you say your name for the record?
Jaden.
Judge, today's time and date, we had this matter up before. My client's originally charged with assault and battery. Prosecutors I believe is offering a count 2 of disturbing the peace. My client would like to plead to that, but he's asking if the court would consider a sentence agreement. He's been in jail since this time, which happened on March 20th of 2024. And if he does successfully plead to disturbing police, I believe that's only a 90 or 93.
I don't know why you're asking me that. I've never done that. 25 years, haven't.
Whoa, that got personal fast. The defense asked for a sentence agreement, which is basically asking the judge to promise a specific outcome before the plea. But this judge just made it crystal clear. In 25 years, he doesn't do that. And when a judge says, "I've never done that," that's not an invitation. That's a warning.
So why are you asking me now?
There's always a first time, Your Honor.
Yeah.
People change.
And apparently, if you see rainbows and unicorns in the back, it's changed.
Judge,
You see them?
Judge, I've noticed as you've got older and more gracious and stuff, you're more open to negotiations.
Older.
Well, I mean, bench-wise, not appearance-wise.
Older.
Oh no, calling the judge older, even bench-wise, is not the persuasion strategy you think it is. Courtrooms run on respect and tone. Humor can work, but it can also blow up instantly. You can literally feel defense counsel realizing, I cannot save this.
I can't save this guy.
Can I have an agreement, old guy? That's what he just said.
No, that's not was my intention, Judge. Listen, I'll be in the nursing home in the next couple of years, so please work with me.
Think it's gonna take that long? No, but
So that the offer is to plead to count 2 of disturbing the peace contrary to section 50170.
we tried that before, didn't we?
Yes, Judge, and you said that we couldn't proceed because there was a victim, but the law clearly states that the prisoner who's in jail, who's the victim, does not have that right except to, may I read this, as an individual who's incarcerated, is not eligible to exercise the privileges and rights established for victims under this article, except for he or she may submit a written statement to the court for considered at sentencing.
And that's correct.
I know that, but thank you for reading it to me.
Thank you.
That still would require, so stay with me here, Mr. Kilwell. If I were to do immediate sentencing, I haven't given that person an opportunity to exercise their right that they do have. Correct?
Correct.
So then if I did that, I'd be violating the statute.
This is actually a really important legal moment. Even though the victim is incarcerated, the statute still gives them the right to submit a statement before sentencing. If the judge rushed sentencing today, that could violate the law and create grounds for appeal. So what looks like delay? It's actually the court protecting the record.
Correct.
Which is what I was saying before. Right?
Correct.
And so now you want me to do what I said I wouldn't do before now.
I should retract that. No, I don't want you. Well, Judge, we'd like to enter the plea today, and whatever the court deems necessary for sentencing, we'll go along with it.
You still want to plead, young man?
I'll leave it to your discretion. Do you want it? They're offering you disturbing the peace. Do you want to plead to that?
I'll plead to disturbing the peace.
You'll plead to that? You understand that I'm going to have to set it out a period of time. I don't know if anybody will respond to any communication or anything, but I have to set it out so that they can at least try to get in touch with the court prior to issuing a sentence on this. You understand that?
Yes. Will I still be able to bond out before?
I'll check on that. I'll check on the polls while we,
No,
He's got other holds, Your Honor.
Yeah, so I don't know that I can answer that anyway.
Right. I'm talking about on this specific case, will I have a bond that where I can bond out?
Just found on this case. What do you have?
It's 1,000.
So it's $100 bond on this case.
That's it's not going to get any lower.
So I don't think I was asking if I'll be able to follow.
Yes, you can pay the $100 on this case, but if you have other holds, you're not.
And here's the harsh reality of criminal court. Yes, this case has a $100 bond, but if you've got other holds, you're not going anywhere. This is something a lot of viewers don't realize. Cases stack. One small bond doesn't override other detainers. Freedom isn't case by case, it's system-wide.
Going anywhere. That's what the judge is asking. So you still want to plead to disturbing the peace?
You wish to plead?
Yes, Your Honor. So I retract everything I said to you before.
I know, you wasted my time once again. Can I have him raise his right hand to be sworn?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Still wish to plead?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind. You had previously signed an advice of rights form. You recall doing that?
No.
All right. Because you're pleading guilty, you understand that you'll not have a trial. Okay, because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak to you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you, and you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that? You understand you're giving up your right to appeal of right. Are you on probation or parole? Which one?
Probation.
All right. Were you on probation at the time of this offense? All right. You were?
I was in at the time of this offense. I was already in jail for a probation violation.
Got you.
I think he was pending a hearing on a violation, so he was technically on probation
At the
at
time.
the time of this as well.
Okay. Are you still on that probation?
Yes, Your Honor.
All right. You understand that your plea in this case could be considered another violation of that probation.
Yes, Your Honor.
You understand that as such, if it is, that court could sentence you to the maximum allowable under that other charge.
Yes, Your Honor.
And understanding that, you still wish to...
This is the part that should make everyone sit up. He was already on probation, and this new plea could trigger a violation. That means even though disturbing the peace carries up to 90 days, the probation court could sentence him to the maximum on the original charge. Sometimes the bigger risk isn't the new case, it's the old one coming back to life.
to plead guilty to this charge? Has anybody promised you anything other than what's been stated here today to get you to plead to this charge of disturbing the peace?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily of your own free will, right? And also because you think that you're guilty. On the date of March 20th, 2024, at the location of 2201 Hogback Road, that being the Western County Jail, what'd you do that makes you think that you're guilty?
Order bodily fluid.
Okay. And in doing that, that disturbed the peace and repose of the area around you? Yes? And you knew that that's what it did? Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
The court will accept the defendant's plea to count two. Count one is dismissed.
And just like that, count one, assault and battery, is dismissed. That's significant. Pleading to disturbing the peace reduced the exposure dramatically.
But sentencing isn't today. The judge ordered a pre-sentence investigation, which means probation will dig into background, history, and risk factors. The real question now, does he get time served, or does probation tip the scale?
Pre-sentence investigation and report is ordered through probation. Sentencing on this matter will be December 17th, 2024, 9 a.m.
And I was able to verify that will be enough time for us to contact the victim to see if they wish to provide a statement.
All right, thank you.
Your Honor, will probation come down to the jail to interview him?
I don't know. Yes, they'll get to it.
All right,
Trust
thank you. Thank you, Judge.
We do it every day, all day.
All right, thank you.